Migration has increasingly become a global hot potato, and in South Africa, battles have entered previously uncharted territory as the state pushes back against migration-related litigation. This comes after a recent Constitutional Court decision imposed personal cost orders against the Home Affairs Minister and his Director General and barred their counsel from claiming any fees for the case. Good evening, welcome to Unfiltered. My name is Sizwe Mpofu Walsh. As countries increasingly face internal political pressure from citizens affected by various socio-economic challenges, South Africa is not spared. Many citizens who bear the brunt of illegal migration blame the state for the overburdened social system. With the overhaul of immigration laws that has recently been proposed, will these laws address the migration-related problems that South Africa faces? Well, joining me for this discussion is South Africa's Minister of Home Affairs, Dr. Aaron Motsoaledi. Remember to join this discussion on X using @Unfiltered SABC. Before our discussion, let's look at this insert produced by Genosi Kwene.
Many countries around the world make these reservations as provided for by both the Convention and the Protocol. South Africa, unfortunately, did not make any of these reservations as other countries did. And we believe and we emphasize it was a serious mistake on the part of government.
A rare occasion of a state admitting to its failures. The South African government seeks to exert its authority to comprehensively deal with a litany of immigration-related challenges it faces many years after democracy. This weekend, the Home Affairs Minister Aaron Motsoaledi announced an overhaul of 3 laws: the Citizenship Act of 1995, the Immigration Act of 2002, and the Refugee Act of 1998, to close the gaps that have seen it often hauled to the courts as parties contest the correct interpretation of the country's immigration laws. A political conundrum which has bred fertile ground for rising anti-immigration sentiments as citizens blame their socio-economic conditions on illegal immigrants, a matter that has also seen the governing party, the African National Congress, increasingly becoming more vocal after being accused of laxity in confronting the results of illegal immigration. Experts say the high-profile immigration-related mishaps and endless litigation have been particularly bruising to the department.
I think that this particular minister has been particularly upset and humiliated. This is how he has expressed it, with certain individuals who shouldn't have obtained permanent residence, for example, who have come across the border, and when the police have run after them, I'm thinking of Shepherd Bushiri, for example, they've run across the border back to their home countries without anybody knowing about it.
Last month, the state launched the Border Management Authority to enforce laws across all entry points in the country. Home Affairs Minister admitted that there are no reliable figures on the number of illegal immigrants in the country. The proposed changes are contained in the White Paper on Citizenship, Immigration and Refugee Protection, which is now open for public comment until the 19th of January next year. But will the overhaul of the immigration laws finally address the immigration-related challenges that South Africa faces? Genosi Kwene, Unfiltered, on the SABC channel 404.
Welcome back, Minister. Thank you very much for joining us on Unfiltered.
Thank you, Caesar. Thank you to the viewers and listeners.
The pleasure is ours. And Minister, can you begin by explaining to us the primary motivation behind this very dramatic shift in the White Paper around South Africa's immigration laws?
Well, as you saw in the introduction in the White Paper, we are saying in that area of migration, there are 3 pieces of legislation that are regulating that part. It is the Citizenship Act of 1995, the Refugee Act of 1998, and the Immigration Act of 2002, but there is no overarching policy. There were just pieces of legislation thrown in at various stages or various time after our democracy. And quite often, they clash with each other. They don't speak the same language, and they cause problems. That's why, take for instance the Immigration Act. We enacted it in 2002. It came into operation in 2004, but the same year there was an amendment already. And from there it was amended about 4 times. Even for Home Affairs officials can no longer make head or tail of applies. And the amendment were knee-jerk in trying to solve, when you pass an act, when you apply it, practically you start experiencing exactly how it works. And every time you amend. So we looked at them and said, no, let's start from the beginning. Let's press a restart button, start from the beginning, and have an omnibus law. And we have learned that in other countries, that's what they do. They don't have 3 pieces of legislation. They actually have an omnibus law that controls that area. That's why we're doing what we're doing.
Can you take us into some of those tensions, just to give us an insight into how the Immigration Act, the Refugee Act, and the Citizenship Act have sometimes not been in harmony?
Yeah, let me just give you an example about the Citizenship Act. If you look at it, it's a replica of the Colonial Act of 1949. If you look at it, it looks like we're just taking words there and changing sentences. Why was the Citizenship Act of 1949, why was it passed and what does it denote? If you read it, it was specifically to cover the British from their responsibility in Southern Africa. And when you look at it, it's male chauvinistic. It's male chauvinistic, and it's also a racist. But what we did was just to change the words, like because that one keeps on saying father, 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 as if mothers don't exist. So what we did, we just took it and changed the father to parent. Sure. But the words and the sort of sentiment is more or less the same. And it can't fit in with our democracy. Now you ask questions about where the laws clash with each other. A very popular example is about, which most South Africans will remember, is when the Afghans, people from Afghanistan wanted to come here. The Americans have been in Afghanistan for 20 years. They couldn't tame the Taliban. They dismally failed. And they ran away, literally. They are not saying so, they just said we are disengaging. But literally it was running away. And when a man runs away from battle, they don't say I'm running away. They use some other diplomatic words. They said so. Then they said, look, there are people who were working with us for the past 20 years, helping our administration to tame the Taliban. Obviously, they are going to be in trouble when we go away. They said they'll have to take them to America. But they don't take them there immediately. I received a letter some few months after that from a lawyer who studied in America saying, those people can't go to America, they need to be vetted. But during that vetting, they must be in South Africa. I said, no, but this can't be. Then a few months later, they actually arrived under a different guise at Beit Bridge. We refused. And of course, they go to court and they win. You know why? Because our lawyers who fought a gallant battle were using the immigration law. But the court pointed them to the Refugee Act,
sure.
which was in Section 2 of that, which is another mistake we need to correct. Section 2 of the Refugee Act, which you passed in 98, says no one may be refused entry into the Republic. Now, see, there's no country on earth that can say that or do something like that. Because no matter how much you love people, there will always be thugs and rascals and unwanted people like them. And that opened the way for international criminals like Rotterdam, what do they call him? Kreger, yes. Palazzolo, Vito Palazzolo. Now recently we had this embarrassment by the United Nations, about Fulgence Kayishema. the genocide here from Rwanda, who during the 1994 genocide, 2,000 women and children ran into a church. Many people take a church to be a sanctuary. He put that church on fire. When he thought it's not burning enough, he got some earth-moving equipment to collapse the walls and ran to South Africa and say, I'm a refugee.
So those are certainly some interesting proposals, and this is a very wide-ranging attempt to amalgamate these laws, Minister. What I suppose I find hard to understand is how long we have waited for this moment, especially when you speak about the Citizenship Act reinscribing forms of racism, being male-centric. Isn't that an indictment on
because
the government
when you read
94?
the act, when you read the act, the present act, you don't see any racism in male-centric because they've replaced the word father to parent and all that. But when you look at the overall thrust of what the act was for, then you start realizing exactly why it's there. And the fact that it is now found in our statute in one or the other, I agree it's an indictment. But the question you ask me, almost everybody who interviews me asks me, since Sunday, when we held this press conference, I always get that asked, why did it take so long? You know, it's like asking, why did we take so long to get liberation in South Africa, to be a sovereign state? Things get ripe and happen at their particular time. One of the things I can say is that for the past 4 years, we have been studying this situation carefully. And we need to be careful with it. For instance, we studied 147 acts. We have quoted them there in the white paper. Not acts, man, 147 court judgments, and found out exactly what the judges are saying. Because sometimes we do blame them, of course, when you get angry. But when you go deeper reading and you realize that, oh, so this is in terms of the law we passed or the conventions that we've entered into. You know, so we had to study those. We had to study all the international conventions very carefully. We had to study what other countries in the world are doing.
But this act was not just when you came in, it was passed in the 90s, so that was nearly 30 years ago at this point.
No, in 2002.
No, we're talking about the Citizenship Act, not the Immigration.
Oh, 1995, yes.
Yeah.
So
that's
quite
30
a long
years,
time ago.
Minister.
Yes, no, I accept that. I do accept that very fully. But you must also know, it was passed even before our Constitution was passed. The Constitution was passed in 1996. We're using the interim Constitution. But also, let's also accept the fact that all these three pieces of legislation, especially the first two, when we passed them, the situation internationally was completely different from what it was now. It was a completely different atmosphere. For instance, here in South Africa, there was Madiba magic, forgiving each other in a way unprecedented. And we're, the rainbow nation of Bishop Desmond Tutu. And we're looking forward. And on this continent, winds of change were blowing hard and fast. Countries that used to be ruled by dictators started saying, you can't be a dictator, there must be elections. Remember, there are countries where there were never elections. They started having elections. Countries where one person can stand for election again and again and again, start saying, okay, 2 terms, at most 3 terms. Countries that were ruled by coups, AU came in and say any country that is ruled by a coup is not recognized. So there was hope that there will be less war and people will stay put only under very extreme conditions. People will start moving around. The situation has changed quite dramatically. Almost every week there is a coup somewhere on the continent, and so there is trouble. And there are rulers now who during the Madiba years put constitution together. Some are pushing them aside and say, now I want the 3rd term, I want this and that. And it makes people move around, and one of the countries always targeted for that movement is South Africa, which when it designed these laws, designed them in a different era. I mean, when you look at this Refugee Act, you actually see that, and it's proven by the number of people who came here. to say, look, we want asylum in our country. There were 11,000 in 1998. But 2008, 200,000 people arrived. The following year, another 200,000. What was happening in 2008? It was when the world economy collapsed. And people believe South Africa is the only one that did not collapse. We were actually in a recession, if you remember. But it also coincided, 2008 coincided with serious economic problems in Zimbabwe. And that's where a problem started.
Right, let's leave it there for now, Minister, but we're going to come back on some of those questions that you've raised and also this new impetus, because it's certainly one of the most wide-ranging attempts to rejig South Africa's immigration legal landscape. Stick with us on Unfiltered. We're speaking exclusively to Dr. Aaron Motsoaledi, and we'll be back after the break to probe the new sweeping reforms to immigration laws. Stay with us. Welcome back to Unfiltered. I'm in conversation with Minister of Home Affairs, Dr. Aaron Motsoaledi. Minister, let's move on to this recent Constitutional Court judgment, because this made for some startling reading. The court really castigated the department, made you pay in your personal capacity as well as the DG, and in a striking move, refused even your lawyers to get their fees, which is something I've never heard of before. Can you explain the circumstances that led to this situation at the Constitutional Court?
Yeah, it was extremely unfortunate. And let me upfront tell you, I don't blame them for leaving for saying we must reverse the payment to that lawyer. I really don't blame them. Because what he did is completely unacceptable. This case started as far back as 2016, long before I was in Home Affairs. The human rights, lawyers for human rights went to court and declared Section 34 of the Immigration Act unconstitutional. In that, it states that when they arrest a person who is illegal and prepare for deportation, the person must request to go to court if they so wish. And the court was saying, no, but it must be automatic. You can't say a person who's in detention is the one who must make a request. They said that is wrong. The second thing being that if you're going to extend their detention beyond the legally permitted period, you go to court and the person is not there. And they said, no, people must come and defend themselves. For that reason, they said it's unconstitutional. You are aware that every law in the country that is declared unconstitutional by a court of law must be confirmed by the Constitutional Court, the Apex Court. And the Apex Court did so in 2017 and gave Parliament 24 months to correct the defect.
Right. Parliament
started in 2018, and they agreed that this is to be a committee bill rather than an executive bill. An executive bill is the one coming from the minister. A committee bill is the one emerging from Parliament. So they agreed that is a committee bill, and Parliament started with it in 2018. And I think they had about 4 meetings to discuss it. Now, when the elections came and they went on an election, the bill lapsed. Bills do lapse from one parliament to the other. And there's a mechanism of saving them, or generally you start from the beginning, because the parliament is regarded as a new entity altogether. It's not a continuation, it's a new entity. Yes, so that happened. Of course, in Home Affairs, I was not aware when I arrived, because during the handover, nobody handed over that to me.
So nobody told you that I think you arrived in May?
Yes, in 2019.
And the deadline set by the Constitutional Court was June that same year. So nobody told you when you got there, the Constitutional Court has given us a deadline and you need to...
No, not at all. Not even after it expired. I discovered it when there were problems in Diepsloot, and I went there with Minister Begitele, and our teams together arrested 2,000 undocumented illegal migrants, and they went to the magistrate, and the magistrate released them because they were saying there's no law, because they argued that since the Constitutional Court gave this deadline, and the deadline passed and Parliament did nothing, so there can't be any law. That's when then problems started. Now, this particular lawyer who went to court on our behalf, the initial ruling agreement by us was that, which we got advice from the Department of Justice, was that since the magistrates are refusing, because the Deputy Minister of Justice had a meeting with them to discuss the matter, they said, no, we are independent, you are a politician, you can't tell us how to make our judgments. And he agreed, he said, the best way is to get the declarator in a court of...
Can I just ask you on that, Minister, because firstly, I think the statements you have made since abiding by the court's decision have really reaffirmed the rule of law and probably haven't been easy for you to make, given that you weren't informed about all of this. But the effectively reading the court's judgment, it seems that you were informed that the department was before the court and you didn't realize that, in fact, the department was before the court and you hadn't sanctioned this massive constitutional action.
No, the first one to go to the court to ask for a declarator, I was aware. And of course, we realized when the court showed us that, but this is wrong, that look, you are coming to the High Court, but the people who finalize this matter is the Constitutional Court, is a higher court. You can't ask us to interpret. The declarator means they must interpret and say, this is what it means. And then we realized that, no, we can't go on now.
But how did they end up going to the Constitutional Court?
No, that's exactly the part that was a problem to me. Even with a lawyer I didn't even know, I did not even speak to, who then went to the Constitutional Court, and affidavit was signed, quoting that is being signed for me.
Absolutely.
And I've never seen it.
I think that was the DG had suggested that
and to tell you the truth, I don't agree even with that affidavit, because the reasons given there are shameful.
So how did the DG say that you were aware when you weren't? Is this something that concerns you?
If you look at the confirmatory affidavit, remember the Constitutional Court said I must give reasons why I can't be charged a personal cost. Yes, when I was doing that affidavit, the DG did write a confirmatory affidavit to say, yes, indeed, the minister didn't know. That's why if you read the judgment carefully, they say the minister did not know, they are satisfied, but he must take responsibility for the actions of his officials. That is what was said, and then they said for that reason, the minister must pay 10% of the cost because he's taking responsibility for the officials working under him.
What kind of actions will you be taking? I know you released a statement saying that you abide by the court's ruling that you're going to pay.
Of course, I'm abiding. I'm abiding. I don't blame the court for that, I must tell you.
But are you going to be taking action, because it's quite outlandish for a whole department to be in court without the minister's knowledge?
Indeed, I've already given this a labor lawyer. Obviously, because one of the things I've learned in Home Affairs, if there's no consequence management to wrong things, they will keep on happening.
Sure.
You know, there might be consequence management, and this particular lawyer, by the way, when I arrived in Home Affairs, looking at these cases, I said, please don't engage this person anymore. I wasn't happy about the work. And unfortunately, I couldn't do that in writing. You know why? The minister is interfering with procurement, because lawyers are usually procured through a normal procurement process. So I told them verbally that please avoid this guy, because I'm not happy about the manner in which he conducts things. But they went and get him without me knowing, and he proved what I was saying by writing an affidavit and even going to court without my knowledge. Let me tell you, you know, sometimes lawyers are procured by the state attorney's office.
Sure.
But yes, without your knowledge, because the litigation arrived at the state attorney, and after all, sometimes they do represent us, you know. So all the lawyers I know of who went to the state attorney's office, they phone and say, Minister, there is this case in your department, it was given to me, can we talk? And you start consultation, because they know the law, I know the facts and figures. the vision and the mandate of the department is known by me, not outside lawyers, not private lawyers who might be very good. They might be senior counsels, but they will show you what the law says. I must show them exactly what is the vision, the mission, and the facts in the department. But this never happened, because if it did, I can assure you, there's no way under the sun I was going to allow such an affidavit to go in court in the name of the department, because the things that are said there, even a very junior lawyer will not say anything of that sort.
And of course, I mean, it must be painful then for you to have to pay in your personal capacity.
It is very painful, but I accept that it is par for the course. Because the judge say I must take responsibility because I'm at the helm. I said, okay, maybe it's that way. It goes with the job. What can I do?
It's been an interesting 5 years in your tenure in terms of court actions. Of course, there's also the ZEP question, and you have recently announced that you're going to petition the Supreme Court of Appeal, I believe. You were denied leave to appeal in that case. Is that petition to the Supreme Court of Appeal, can I confirm that's on, and yes. What was the thinking behind continuing with the appeal action?
No, it is on because we really want to test this and understand it, because we believed right from the beginning what we're doing is wrong. Look, Caesar, the ZEP, when it was given, is not in the laws of the country. It was part of what I told you earlier on when we started. 2008, the number of people rushing into the country saying we're looking for refugee, increasing fivefold from what it was before. And the refugee mechanism, we do have a refugee reception centers, refugee determination officers and all that. They were not designed for that. It was overrun, it was overwhelmed that time in 2008, 2009. And quite a number of people were starting to defraud South African documents. So they said, bring the documents, we'll give you a special permit. Cabinet agreed, and they said, look, let's give them a special permit. Perhaps it will give us time to recover from this overwhelming, and from what cost. There was also a belief, by the way, that maybe things in Zimbabwe might change. And that's why they gave it for 5 years. After 5 years, nothing happened, renewed for 3 years. After another 3 years, nothing changed, renewed. And the question is, for how long are you going to renew something that you put together temporarily? And worse, it said they give it if under 3 conditions. 1, if you can prove that yes, you came illegally, but at least you have got a job. You prove that maybe by a letter from your employer. Secondly, that you might have come illegally, but somehow you were able to acquire an opportunity to study. The institution must give proof. And thirdly, you might have come illegally, but somehow you were able to establish a legitimate business. Once you prove those 3, they give it to you. But then there were conditions added that then you cannot, once you give it to you, you then do not qualify for all the other documents that make people sojourn in South Africa. What were you talking about? We've got 17 types of visas which people apply for. Now, this particular group of Zimbabweans who were given ZEP, also there's another group of Basotho who were given from Lesotho. They were saying, once we give you this, because it's a special thing outside the law, we're just doing it to resolve a particular conundrum, a problem. You cannot then qualify for the other regular visas which are in the law. All the other people will qualify for that. Indeed, there are many Zimbabweans who are here on study visa, critical skills visa, general work visa, who are not on ZEP. But then problems started, and they were going to explode at some stage. People get married. And the law says if you get married in South Africa, you cannot, you can apply for permanent residence and finally for naturalization by virtue of marriage. Now imagine them telling you, no, you have married, but you don't qualify because you are on a ZEP. Then some came to study, and and they got that ZEP. And then they pass, then there's a critical skills visa, which you can get and come in on critical skill. Imagine being told again that, no, your critical skill is not recognized because so inconsistency started, where some were even given, others were not, and all that. And the whole thing was in shambles. Then I realized there's going to be trouble here. And at any rate, it holds people's back. I said, no, let's stop this thing called ZEP and ask these people to apply for the regular visa, 17 of them, like anybody else.
So, Minister, just on that, because I think your explanation is interesting, and it seems to me that it's based in facts and of course a lot of pressure that is being put on the South African immigration system. But it seems to me that the court wasn't so much worried in that reasoning, but rather the process by which the announcement of the refusal to renew happened. So is appealing the decision the best way to go about it, or why not simply restart the process and maybe get on with?
Because it's even difficult to see how we are going to restart it. But it's a pity that now the court is still going to sit and I'm sitting in front of you doing a court hearing. I don't think it's appropriate. If you allow us, please, let's deal with other things, because
fair enough.
Yes, because they'll say the matter is sub judice.
Indeed.
Yes.
Well, you say that at the right time, because we're just about to go to a break and we'll move on to other questions, particularly in the nearly 5 years since Minister Motsoaledi has been Home Affairs Minister. What are his greatest successes and what have been the most difficult challenges? We'll review that when we come back from the break. Stay with Unfiltered. Welcome back to Unfiltered. I'm in conversation with Home Affairs Minister Dr. Aaron Motsoaledi. Minister, I wonder what you think your biggest achievements have been over this last term. We know there's an election coming up. You've been minister for nearly 5 years now in this portfolio. What have been the biggest achievements in your view?
Well, the biggest achievement I'm really proud of is the establishment of the third law enforcement agency in the country, the Border Management Authority. Because throughout these years, there have been a lot of complaints and noise about porous borders. The fact that within this period, we're able to get, even if it was not started by me, I must confess, it's not my idea. It was the idea of NICOC as far back as 2009, but it was stuck somewhere. And we unstuck it, passed the Act of Parliament, appointed the commissioner and 2 deputy commissioners, trained border guards, deployed the first group to the borders on the 14th of July last year, and divided the border into the borderline into 10 segments and deployed them to the most vulnerable part of the borders after studying them. Get the president to come and officially establish and launch the Border Management Authority as the third law enforcement agency after the army and the police, and added 600 border guards. That to me, because now what was happening or what's going to happen at the borders will be completely different from what was happening in the past. The other achievement which I'm really proud of is the fact that we have got a policy that children must be given birth certificate 30 days after birth to avoid a very tedious process which many people don't know about, a process called LRB, late registration of birth. It's a very tedious process. It's a process that Thabo Bester has to go through. It's very difficult for both the yes, because he was already 36 years without any document whatsoever. So the late registration of birth needs lots of documentation and lots of investigation. To avoid that, children must take IDs 30 days of birth. Now, to help them, we establish Home Affairs offices in hospitals. The process was there, the program was there, but I mean establishing some Home Affairs offices in hospitals, but it was not programmatic. We started the programmatic program, divided the hospitals into categories. For instance, we said there are 4,000 public and private hospitals in the country, but birth is taking place only in 1,440 of them. We divided them into categories, those which have got, which deliver more than 5,000 babies. Then we put a fully fledged Home Affairs office, but only giving birth certificate. The others which are delivering less than 500 babies per annum, Home Affairs officials keep on visiting, but it's not there full time. And we put the number of hospitals there. Look at those which deliver 85% of the population, 85% of the babies per annum. And say those ones we want to make sure that they've got Home Affairs officials. And we put them up. As I'm speaking now, we are short of 91. We've been driving them, we're short of 91. And we're very happy about it. The other thing that we are looking for is that the smart card was established in 2013. But even now we still have two types of IDs because some Home Affairs offices are not modernized. They cannot give you a smart card or a passport. We are now piloting, it's still in the pilot stages, a kiosk which will announce when it's ready. A kiosk where all the people who have got the old ID can go and arrange for themselves a new one, just like when you do at the ATM. We are putting something like that very soon. We'll be announcing it and saying the old ID is no longer wanted. But we also, in trying to fight the queues in Home Affairs, we establish a new system called BAPS, where you don't wake up early and queue. You apply online in the BAPS system, and they give you the time at which you must come. And we are trying that when you come in, you mustn't spend more than 15 minutes in the department. Sure. And we are happy that more than 1 million people have successfully used that BAPS. You are aware that we are establishing Home Affairs offices in malls. We have already opened one in Menlyn Mall, and people are very happy about it. We are now busy making arrangements in Cresta Mall and Southgate Mall here in Gauteng, the Pavilion in eThekwini, and Tiger Valley in Western Cape. And we are very happy about those type of developments. And the Home Affairs all these years have been having 100 trucks. We call them Home Affairs on wheels. We increased them by 20. And as I'm speaking, we've ordered an extra 100. And we agreed that we'll keep on ordering that. We want to move them to 1,000. Because one of the things we want to achieve is that it breaks my heart to visit the Home Affairs office and find children there in school uniform. During school hours, they need the documents. But during school hours, I would like Home Affairs to go to schools and not kids to go to Home Affairs. And the only time we can do so is if we have enough trucks. That's why we have ordered an extra 100, which means if we get that 100, which we'll get before the end of this year, and we will start working on them to unveil them early next year, which means we'll have increased our fleet by 120%. And that, to me, I'm very happy about that. But we'll keep on increasing until there are 1,000.
No, it's a series of interventions, and of course sometimes the court battles hog the headlines, but it's also interesting to hear what you feel has been achieved in your tenure. Of course, you were also Health Minister before Home Affairs Minister, and I wonder what which one is tougher?
Well, let me be fair. I was in health for 10 years. I was also an MEC for education. I was an MEC for agriculture. I was an MEC for transport, even if just for 9 months. But I've never experienced the amount of litigation. In health, the litigation was not about what's happening. It was about what's happening in the hospital ward, sure, where patients are suing for mismanagement or whatever. But here in Home Affairs, I've never seen litigation the way we are experiencing it. That's why in my bag, I'm running out. These books, there is the Constitution and the laws of the department and all that. I run with them in my bag. I'm eventually actually becoming a mini lawyer.
You're an SC now.
Well, not yet at that level, but I had to learn, and I've realized that I didn't know these things before.
Is that the most difficult?
I never knew how to interpret the notice of emotion, and now I know. I know the prayers. When they say these are the prayers. At some stage, just last month, there were 35 cases that were going to court, lining up. and 20 of them were people who are not South Africans who were coming here and suing them. And one of them was suing us for 1.1 billion and saying we have delayed these documents, it could have been advanced now, and stories like those. And imagine having to pay 1.1 billion to somebody who came into a country and then is blaming you for not being able to serve him, you know.
So is the litigation the toughest part of this job? And also it seems that there are many NGOs in the sector who are interested in the sector and have brought a raft of litigation.
Yes.
What are your thoughts on that and its impact on the work on?
Well, and they do, because some of them, they believe their job is to bring people into the country, and that's why at some stage, long before I arrived in Home Affairs, they actually banned what they call immigration practitioners. People who practice immigration, who say, look, they open an office for that and say, I'm an expert in immigration. If you want to settle, to come into South Africa, you have got to go through me and pay me. And some of them charge huge amounts of money, like 15,000 rand and all that. And the Home Affairs realized that there's a lot of corruption in that. Because if you open that office and show people that you can only settle in South Africa through me, you then get tempted to go to Home Affairs office and bribe some officials to make sure that anybody who comes through you becomes successful. Then all the other poor people who are coming through legal channels, they don't get anything. So those are some of the problems that are there, because some of the people, and I listen to them, sometimes they get called to our TV stations and they say, here is an expert in immigration. He's not an expert. He's making money out of immigration, for goodness sake. And I said, give him a correct title. When you say he's an expert, you make the public believe he knows everything. He doesn't know everything. That's his livelihood. That's what made him put bread on his table. And he used whatever method to do that.
Well, we're in conversation with Dr. Aaron Motsoaledi, an interesting and wide-ranging conversation on the recent white paper, which proposes a raft of new immigration-related legal interventions, also recent court cases and his response to those court cases, and now a reflection on his almost 5 years tenure. We'll be back after this with some of your comments from social media and a wrapping up of our show. Don't go anywhere. Stick with Unfiltered.
What effect is the lack of edutainment having on our youth?
When the content moved out of the space post 2016, then we lost touch with young people.
Let's go back to maybe what we did right as a country.
In the times when we were dealing with things right, we were caring about young people, underline caring about young people.
I think as young people, they're dealing with so many more different problems and issues than we did 10, 20, 30 years ago. And they don't have the tools necessarily to cope.
It's extremely important then that we release the children from the shackles of only English. We release the children from the shackles of being separated from the grown-ups. We grew by having intergenerational dialogues.
Join me, Naledi Muleo, on Media and Society every Sunday from 9 a.m. to 10 a.m. on the SABC News channel.
The World Bank has approved a $1 billion loan to help South Africa deal with its power crisis.
Former acting Eskom CEO Matjela Goko and 18 others is expected to take to the witness stand.
We're expecting unemployment to stay around that 3.8% level.
Market news now: Asian shares rebounded from 11-month lows as a plunge in oil prices and softer US labor data.
The public hearings for the Usindiso building fire inquiry commenced.
Welcome back to Unfiltered. I'm in conversation with Home Affairs Minister Dr. Aaron Motsoaledi. I promised we'd go to some of your comments on social media, and let's have a look at those and put them to the Minister now. Mzuvukile says immigration law changes will address SA's challenges because NGOs who are opposing Dr. Motsoaledi are using the loopholes which are found in the law. Let's have another look at some of your comments. BM says, how will the minister deal with those who already have South African IDs? And finally, Hassi says, may you please ask the minister, how does an immigrant study a critical skill in South Africa? Let it make sense. Those are some of your comments from social media. Minister, you can reply to any or all.
Let me start with the last one. The critical skill, you don't necessarily start in South Africa. What happens is every 4 years until now, because we have just changed, the Minister of Home Affairs must gazette a list of skills that are regarded to be critical. And people confuse this issue of critical. Critical means skills that are needed by the economy, but we don't have them in sufficient numbers in South Africa when they are needed. You know, so the Home Affairs Department must gazette them. But Home Affairs doesn't have that skill. How does Home Affairs know which skills are needed? So we go to those who know. It is usually the Department of Higher Education. But even them, they'll go to Human Science Research Council, who will do their studies, go to the labor market survey, and then take the list to NETLEC, where you find business, big business, which they are the ones who know which skills they need. Then you find labor, then you find community and the state. They sit together to work on that list. Then we send it to the presidency. When we are happy, Home Affairs gazette it. What it means then is any person who has got a skill which appears there can apply for critical skill. In 2014, they did it wrongly. We had to correct it. I'm saying wrongly because it allowed you to come to South Africa to look for a job on the basis that you have got a critical skill. In the new one, we are saying, no, show us the job first. The employer must say, I need this person, because the skill is not readily available in South Africa, and give you a letter of appointment is then that you come to Home Affairs. Now, we have agreed recently that we don't have to wait for 4 years. Every time we identify a critical skill, we gazette. That's why this year we've already gazetted 3 times. The first one in February, then we gazetted again, I think in June or July, and then recently. Every time we discover something that is a critical skill. So some people apply to study in South Africa at the university. If the university gives them permission, we in Home Affairs have to give them a study permit. So after studying, some of them discover that, oh, what I've studied for actually appears on that list of critical skills. And then if they are given a job, if it was 2014, they will just say, oh, so I appear on the critical skills list, I deserve to be in South Africa. So we have stopped that. You must get the job first. Somebody must employ you. Yeah.
Any other of the social media comments also feel free to respond to. But can I also just come to, in some ways where we started, Minister, with these new reforms that you're proposing to South Africa's immigration laws, which are really generational changes. What is the timeline for the actual fruition of this? Because of course, the white paper is one thing, but to repeal laws requires Parliament then to amalgamate these laws and to pass them could be years.
Yeah, indeed, because these are 3 acts. But what we're saying is, let's start with the foundation. And the foundation is a policy, which hitherto did not exist, a new policy. And that's what the white paper is going to be. So we have sent out for public comment, and the deadline is the 19th of January next year. From there, we'll incorporate all the inputs, and I think there are going to be 1,000. Very recently, we were asking for inputs for the new Marriage Act. We got 11,000 pieces, different inputs, and we have to incorporate them, and insert them. You can't just ignore them. So we're going to have to do that. I don't know how long it will take. Then send it back to Cabinet. If it approves it, then it's the white paper. At least we have got a policy. Then the job of enacting a law, a bill for citizenship, a bill for refugee, a bill for immigration, then you send them to Parliament. So it is quite a process.
And that's all going to be one law, as I understand it. So you're taking these 3 laws and you're trying to put them together in one
it becomes one omnibus law that deals with citizenship, it deals with refugee, it deals with immigration.
Is this bowing to pressure? Of course, there's been a lot of pressure on the state around questions of undocumented migrants.
Well, there are people who are saying we're bowing to that, and because it's election. I told you this work started 4 years ago. 4 years full that we've been sitting because we didn't want to do a half-baked white paper. We wanted to study what's happening in other parts of the world, what are the international conventions, and that's when then we discovered that in our accession to this international convention, certain mistakes were done. Because, for instance, let's look at the United Nations Convention of 1951. It has got 46 articles. Article 42 specifically gives states the right to put in some reservation and say, why we are ratifying this, but we are posting this reservation. And the reservations are very important, and I know people don't want them, don't know about them. They don't know what I'm talking about. I don't know whether we can allow you 2 minutes just to read one reservation here.
By all means, but that's all we'll have time for, Minister.
Yeah. And because the Zimbabwe is always a subject, I'll look at the reservation posted by them in 1981, when they entered the convention. Here it is. It is. Zimbabwe said the government of the Republic of Zimbabwe wishes to state with regard to Article 17. Article 17 of the convention, of 1951 convention, is about wage earning employment. And Zimbabwe said no. The government of the Republic wishes to state with regard to this article, paragraph 2 of it, that it does not consider itself bound to grant refugee who fulfills any of the conditions in paragraph A and C automatic exemptions. What is paragraph A and C is where they are saying if a person stayed 3 years in your department, in your country, they must be allowed a right for wage earning employment if the person is married in that particular country, if you have got children. And they are saying, no, we don't feel like we are bound by that. We'll sign the convention, but that doesn't bind us.
And this is what you're saying we need to do with
we need to look into. I'm not necessarily saying this one.
Sure.
But things like those, because they deal with the economy.
That's quite normal,
yeah. If you look at the UK is about NHI, which they call NHS. The UK is saying, look, we don't feel the pressure yet. They said that in 1951, by the way. They were looking forward. They said we don't feel pressure on our NHS, National Health System, but in future, if we feel the pressure, we reserve the right to charge a fee to anybody who use our health services who is not ordinarily resident in Britain. Those are the type of reservations that they put there. And I'm not saying we'll put that. There are many types of reservation to do with your culture, your religion, the state of the economy. For instance, there are people who ask me, you want to take socio-economic right away? It's wrong to promise people that which you are not able to achieve. For instance, if you promise that anybody who comes from any part of the world can come to South Africa, they will get a free house, will that be possible? Now we are already borrowing money. Can we offer anybody and say, no, come?
Right.
Because there is free housing, you can get it, you deserve it. If the whole world comes here, will you give them the free housing? Isn't that very unrealistic?
Well, Minister, we await some of the reservations and we will certainly await the public's response to the white paper that you have proposed. Thank you very much for joining us for such a wide-ranging conversation and even reading from some of your files, which I'm told you carry around everywhere you go. Thank you very much, Minister. Thank you for joining us again on Unfiltered this evening. We have delved deep into South Africa's immigration laws and the proposals to upgrade them. Do you agree with the proposed steps from the Minister of Home Affairs? Let's continue this conversation on social media at Unfiltered SABC. And remember to stay tuned for unfiltered news, unfiltered views, and more unfiltered conversations. Have a good night.